Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast of the Antitrust Law section of the American Bar Association. My name is John Roberti. And today's episode is How the Case Was Won, the Processed Eggs Products Antitrust Litigation. Earlier in our series, we did a program on a merger trial and talked about all the intricacies that went into that. It's fascinating to learn what worked and what didn't. We wanted to take a slightly different tact here and talk about a trial that wasn't a merger trial, but one that is more, let's say, typical antitrust litigation. We're going to talk to a trial team from Columbus, Ohio, and also Washington, D.C., who had the rare chance to defend their client in an antitrust class action suit all the way to a jury verdict, not once, but twice, in 6-week trials, just 18 months apart. It is very, very rare to go to trial in an antitrust case. To get to go twice on the same case is very, very unusual. And we'll learn a little bit more about some of the appeals and find out, how the case was won. With me today is my co-host, Alicia Downey. Hi, Alicia.
Hi, John.
Alicia, what are we doing today?
Well, as you mentioned, we're going to be talking to two members of the trial team that went through these trials all the way through a jury verdict. We're also going to get into the issues raised in the appeals from both trials, including the Third Circuit's June 2020 opinion affirming the judgment in the first trial, which is posted on the episode webpage. And
why is this important?
Well, I think, as you mentioned, it's rare for cases like this to go all the way through to a jury verdict, much less twice. And I think we'll hear from our guests there may be a third trial on the horizon. These are big cases, class action suits in particular, and this was one, typically settle. So we're going to hear about what kinds of trial themes appealed to the jury, and how these trial team members managed to survive over so many weeks of trial.
All right, who are our guests?
Well, with us today are two partners from the law firm of Porter Wright. We have Jay Levine. Hi, Jay.
How you doing, Alicia?
And Jim King. Hello, Jim.
Hello.
So what I'd like to do then is try to get a quick overview. And Jay, I'm going to ask you to do this. What are these cases about and how did they start?
Sure. Way back when in 2008, there was a New York Times article that talked about some issues in the egg industry. And that sort of spurred a number of lawsuits that were filed between 2008 and 2010, essentially alleging that the egg industry ag co-op, United Egg Producers, UEP, and another associated ag co-op, United States Egg Marketers, together with some large egg producers, allegedly conspired to reduce the production and supply of eggs in order to raise prices. And they got consolidated in Philadelphia in the MDL, and they've been going on since 2008.
So that's over 10 years at this point. Now, I assume there were some motions for summary judgment along the way. Were there any key rulings in that phase that sort of shaped the first trial?
Sure. There were, initially there was class certification for both a direct purchaser class as well as a consumer class. The judge certified a direct purchaser class, but actually refused to certify a consumer class, and then a number of companies opted out of the class, and that became what we call the DAP trial, the direct action purchasers. And at summary judgment, everyone filed summary judgment briefs, but the key ruling there is that the plaintiffs had alleged that the alleged conspiracy was per se illegal, was supply manipulation, and was per se illegal, which means once you can prove that there's an agreement, they don't have to prove any anti-competitive effects, and there's no justifications that get to be considered. And at summary judgment, some of the defendants brought a motion asking for the rule of reason to govern the case, and the judge ruled that the rule of reason will govern at least part of the case, the certified program, which was the key, aspect of the alleged conspiracy, where the ag co-op had a certification program for animal welfare, and that the plaintiff said that program reduced the supply of eggs, but the judge had ruled that it's going to be judged by the rule of reason, and that ended up governing both trials.
So, and now I want to turn to Jim. Let's fast forward then to 2018, and the team's gearing up for the very first trial. Tell us a little bit about your client, and what were the stakes that it faced if it lost?
Our client is Roseacre Farms. They're a family-owned operation out of Seymour, Indiana. They are the second largest egg producer in the United States. They started in the 1950s, a very modest farm, family farm, and it's grown, as I said, to be one of the largest egg producers in the United States. The stakes in this case were enormous. The plaintiffs, both the class plaintiffs and the opt-out plaintiffs, were seeking in excess of $1 billion in damages. And as I'm sure a lot of your listeners know, under the Sherman Act, if they were able to succeed, those damages would be trebled. So what they were facing was a catastrophic loss in the event of an adverse jury verdict.
And so how many people did you have on your team then for the defense of Roseacre?
Well, the actual trial, the direct purchaser class trial, the first one, which occurred in 2018, our trial team consisted of about, I think if I have my numbers right, about 6 lawyers at the courthouse. We had a number of folks helping us back in Washington and in Columbus, probably another 4 or 5. So, and then we had paralegal support, both on site and back at the home offices. So probably about a dozen people.
And turning back to you, Jay, were you in the courtroom for the entirety of the trial, and what was your role? I was in the court the entirety of both trials. I was one of the trial lawyers examining and cross-examining witnesses. I guess I concentrated most on the experts and some of the more antitrust issues that we argued in front of the judge, as well as some of the executives at Roseacre who dealt with kind of the production of eggs and the like. But I got to live through it day in and day out as well in the courts. And Jim, I think most people who've done any litigation understand the importance of themes and trial themes. Can you talk a little bit about the themes that your team used, and also the plaintiff's themes?
Well, I'm a big advocate of coming up with a single trial theme, singular, not plural. We would have a number of arguments to advance that theme, but the theme that we came up with for the class trial wasn't very original, but it was actions speak louder than words. And we came up with that theme because the whole theory of the case was that Roseacre and others within the egg industry, along with the this trade cooperative that the industry was a member of, had conspired to reduce the supply of eggs in order to raise prices. And during a period of time beginning sometime around 2002. And if you looked at the period of time, the conspiracy period that the plaintiffs were alleging, Roseacre did not reduce any of its supply. In fact, it expanded its production by a lot. And if you look at overall egg production, shell egg production in the United States during the same time, it also went up, and wholesale egg prices went down. The problem that we faced was that there were a number of comments, mainly in newsletters, but also in other correspondence from leadership within this trade cooperative that as an attempt to try to sell mainly the animal welfare program, which was the centerpiece of the plaintiff's case. A way to sell that is that the leadership thought to convince its members to sign up for this animal welfare program that, hey, if you do this, we have a chance here to restrict supply and raise prices. And there were a number of those statements that we had to contend with. But those statements didn't actually reflect what happened in the real world, both by the actions of our client, Roseacre Farms, and the actions of the industry. And if you looked at actually what happened in the real world, the egg prices went down and egg supplies went up. So we said, look at what we did, not at what others were saying. So that's how we got to the actions speak louder than words.
So
go ahead.
Well, I was going to say, so you got over the hump of bad documents, which is probably an understatement given how you've described them. Spoiler alert, you won. So what I want to do now is, kind of turn to the appeal. There was an appeal taken from that defense verdict, and ask Jay maybe to quickly outline what the issues were that the plaintiffs asked, and it was the Third Circuit, I guess, to consider.
Sure. Well, so the verdict form had 4 questions on it. The first was there an alleged conspiracy to reduce supply? The second was, did any of the defendants, and there were essentially 3 producer defendants. We were by far the largest of the 3, and did one by one, did any of us actually participate? The third question was, if there was a conspiracy, was it unreasonable? The rule of reason question. And then the fourth question was, was the class injured by it? And so the jury answered that there was an alleged conspiracy, that the other 2 defendants did not participate in that alleged conspiracy, but that Roseacre did, but answered number 3, that the conduct was not unreasonable. And so the plaintiffs had moved, did argue under Rule 51. They tried to change the judgment. The judge had entered judgment for all of the defendants. And then on appeal, essentially, they argued that once the jury came to the conclusion that we were part of an alleged conspiracy, the judge should never have asked question 3, that it mandated a per se treatment. And that was sort of case specific. And then they also argued more generally that the conduct that they've alleged should have been governed by per se standards anyway, and not the rule of reason. And then, as you alluded to, the Third Circuit in June 2020 agreed with our position that it's not how the plaintiffs characterize the alleged conspiracy that governs what treatment it is, but what the conduct is. And then they found that the judge was correct in ruling that the conduct was subject to the rule of reason, and that not every agreement is necessarily per se, and that having question 3 in there was appropriate, and affirmed the judgment.
So now I want to jump forward in time to late 2019, and it's another trial, and you're looking at another multi-week period spent out of town. And this time, who were the plaintiffs? Jim, can you just set the stage for the second trial?
So the second trial consisted of opt-outs, and the opt-outs here were supermarket chains. A laundry list of supermarkets that I'm sure all of us have heard of: Safeway, SuperValue, Giant Eagle, Kroger, etc., Walgreens. They were basically raising the exact same claims, that there was a multi-part conspiracy, at the center of which was this animal welfare program that the industry agreed to, that was developed by this trade cooperative.
Did you change your approach based on the experience in the first trial?
Well, in the first trial, one of the things that we brought out was that Roseacre agreed to this animal welfare program because its customers demanded it. It was something that its customers required in order to satisfy the demands of its customers. It agreed to subscribe to this animal welfare program. The class representatives weren't any of our customers, so we made that argument, but we didn't make it directly to the plaintiffs. Here, though, the supermarket chains were Roseacre's customers, and we had lots of evidence that they, in fact, did demand and require in their contracts, in their specifications, adherence to this animal welfare program. So, and we emphasized that a lot during the trial. The theme for this trial was that the marketplace worked, and the marketplace worked because Roseacre was responding to customer demand.
And I understand that an appeal is pending in that case. Jay, what are the issues that have been raised there, and what's the status?
Briefing was just completed in that about a week and a half ago. So I suspect that argument will come, in the next 6 to 8 weeks, and then probably a couple months after that for an opinion. And here they also did appeal the rule of reason per se issue. The interesting thing is the Third Circuit's ruling in the class case affirming the use of the rule of reason came actually during our opposition brief. So we actually had to rewrite our opposition brief to incorporate the Third Circuit's opinion quickly. So that's one issue. The other issue, which really wasn't present in the class, is that as we said, the certified program was the cornerstone of the alleged conspiracy, but there were two other components to it. There were exports, as well as the ag co-op had made certain recommendations to producers to adjust their supply to meet sort of low demand or the like. And the plaintiffs had argued that all three components are part of this alleged overarching conspiracy to reduce supply. But at trial, they wanted the judge define the conspiracy as including all three components, and they argued that not all three components have to be found to be part of the same conspiracy for there to be the conspiracy that would violate the antitrust laws. So on appeal, they're arguing that the judge was wrong to force the jury to find that all three were part of the same single conspiracy, even though, as we've argued, that has been their theory of the case since they filed their complaint all the way up through and including trial. So that's their main issue on appeal.
Okay. And then a question for both of you, because I'd like to see if your answers are different. We'll start with Jim. Do you think that these trial victories, and let's assume the second one's also held up on appeal, but as we know, anything can happen. Do you think that these victories will give defendants the courage to take more antitrust class action suits to trial?
I probably not. I don't think so. I mean, we had a unique set of circumstances where basically we just didn't have any fruitful discussions on settlement that basically forced our hand to try the case. Essentially, Jay, what are your thoughts?
Yeah, I everyone's circumstances is different. I think maybe at the margin, this can give someone a little bit more courage. But by and large, I think every company makes settlement decisions on their own. I think what it might do is it might help people, if they're considering sort of industry type cooperation, it might embolden them to engage in that and not shy away from a little bit more. But to take a case to trial, this was literally bet the company litigation. And I just don't know how many companies are willing to risk it.
And for each of you, what was the either a memorable moment or the most memorable moment in either of the two trials? Jim, you first.
I think probably the most memorable moment for both trials for me is when we realized we won. When you get that, when you get a defense verdict, there's nothing like it. And our client again is a family-owned farm. Members of that family were in attendance, and they were ecstatic. They couldn't have been happier. And for me, all the work, all the sweat, all the long nights, all the restless nights, all the lack of sleep, it was all worth it in the end.
Jay, how about you?
I'd probably agree with Jim that, in the first trial, when they first answered, yes, there is a conspiracy, and yes, Roseacre was part of it, you're really primed. And my head was, this was a bifurcated trial. So liability was tried first, and then we were going to try damages. And immediately my mind is turning towards, okay, well, who am I putting on for damage? What am I, and then all of a sudden when they said that the conduct was not unreasonable, actually, this was also my most humorous moment. Jim was sitting on the end and I was sitting next to him, and we're both looking stoic, and he sort of nudged me and sub salento says, that means we won, right? And I whisper back, yes. And we're both looking stoically. And that was just incredibly gratifying. And then of course, in the opt-out trial where they said there was no conspiracy whatsoever, that, you don't realize how much tension your body is possessing until you hear that and just let it out. And then the family, many of them were there, including the next generation of the family who's, becoming now the up and coming executives in the company, and their legacy was preserved. And, a lot of tears, a lot of happy tears, a lot of hugging. And that was probably the most gratifying.
Alan Carter and Arlene Boruchowitz, the younger trial team members, also provided us with their most memorable moments of the trial.
So the easy answer is the verdict being read. But aside from that, winning's always nice. But the other things that really stand out are moments when a piece of evidence is presented in a way that really just drives home the point you're trying to make, and you just kind of get to see lots and lots of hard work result in success in the matter of seconds, and you can see how the jury reacts to it, and they react to the way that you always envision them reacting. Those things make all that hard work just really worthwhile.
For me, the most memorable moment of the trial was definitely watching Jim do our closing. I think closing is really satisfying. I think even Jim would tell you that usually the jury's decided before closing happens, but closing is really satisfying because, you work hard the entire trial to try and gather all these great bits of evidence to help your case. And then at the end of the trial, you spend all this time pulling those bits of evidence and compiling them for the closing presentation. And so getting to do all that and then getting to watch Jim pull off this great performance as he always does in closing was just really satisfying. And we also had a really great trial graphics teams that also helped to make closing really shine. So getting to have the visual representations and the snippets of depo testimony and all the video deposition testimony and all of those type of visual aids in addition to Jim's presentation it was really satisfying to see everything come together like that at the end.
And if I could just follow up on one thing with respect to the verdicts. In the first trial, the class trial, the jury deliberated for, I think, a little over a week. And we thought for sure, and if I had to guess, I think the plaintiff's counsel also thought the same, that we were headed towards a mistrial because the jury came back several times indicating that they were deadlocked. They even said they were hopelessly deadlocked, and the judge gave what is known as an Allen charge, telling the jury to go back and deliberate. And we thought for sure that we were going to have a mistrial, but we didn't, and which was a great relief to us. As opposed to the second trial, the jury was out for about a day before it returned its verdict. So just two very different experiences with those two juries.
Well, thanks. You really painted a vivid picture. I think that wraps up this segment of the program. Let me turn it over to John Roberti.
Well, and before we leave, I actually would like to ask you guys a question. How did you incorporate your young lawyers into your trial preparation? And did you give any thought to trying to make sure they had interesting experience? Jim, maybe we could start with you and then Jay.
Well, we start off the trial with an assignment of witnesses. You have witnesses that you anticipate the plaintiffs are going to call, and you have witnesses that you anticipate that the defense will call. Those get winnowed down. Witnesses get shed. That's a common experience. But there were witnesses that we had identified that we thought would be I shouldn't say safe witnesses, but witnesses that were not very difficult to examine, that we brought in our younger, more junior lawyers to get that experience, bring them in and have them conduct direct examinations. At least for this trial, we didn't bring in any of the younger associates to do cross-examinations, and they all did great. It happened in both the class trial and in the opt-out trial.
Jay, how about you? How did you work in the young associates?
Well, again, they were intimately involved in witness prep, doing the witness outlines, the cross-examination outlines, working with us to prep our witnesses and the like. And Jim's right. In the first trial, we didn't initially assign any witnesses to junior associates, but as things got on and, we thought they heard enough from Jim and me, we gave a couple of witnesses to some junior associates. Unfortunately, one got pulled, so one of the associates didn't get to examine. But then in this second trial, two of my witnesses, we thought both of our two junior associates would do a wonderful job, and they really did. And so having them help and having them also sort of help guide the, with the economists, which is, sometimes very technical and very laborious work, but they helped us with both direct examinations and the cross, and working with our graphics experts, especially to come up with some absolutely compelling and amazing graphics.
We had a chance to speak to two of the younger trial team members, Arlene Boruchowitz and Alan Carter. And I asked them to tell us about what opportunities working on the trials gave to them and what lessons did they learn. And here's what Arlene and Alan had to say.
During trial, I had the opportunity to do a direct examination of one of our expert witnesses, which was definitely an excellent opportunity for me as a young lawyer. Trial experience is rare enough, but especially getting to examine a witness is especially rare. So I was fortunate to be able to do that. I think some of the lessons that I learned, which is something that you can only learn if you actually do examinations for real, and as opposed to trial practice class or things like that, is just to know that you can prepare as perfectly as you think you can, but there's always going to be an objection. So you just always have to be prepared for that and be on your feet and ready to think quickly. And that's part of being a lawyer. And I think that's just one of those things that you have to have some experience to learn. And then also, just as with everything in the law, I think you have to have confidence when you get to do anything important in a trial. You have to have confidence. So those are the lessons I learned.
The opportunities I had in the courtroom were, on par with what you would expect for an associate in a multi-week, multi-billion-dollar trial, but maybe a little more than that. In the second trial, I was able to argue motions and examine Roseacre's chief financial officer. And what were the lessons I learned? Two lessons really stick out in my mind. One is one that Jim King really hammered it into me and us, which is that credibility is paramount in a jury trial. We cannot do anything that might lose any credibility with the jury, even going down to making sure we have the right amount of copies of exhibits to distribute in the courtroom. But more than that, can't make any fringe arguments or arguments that doesn't stand to reason or is too complicated for a jury to understand. And I guess that kind of leads me into the second lesson that I learned, which is the jury is just not going to remember all the details and all the facts that were presented to them at trial. So what you're really trying to do is build the big picture. And in doing so, the details matter, the brush strokes matter, so to speak, but you got to keep your focus on making sure those strokes align with the big picture that you want the jury to see at the end of the day, because they're not going to be looking at the details, although the details matter. They're going to be looking at what was the big picture that was presented to them, and was that big picture proven out.
That's a great comment. Turning back to Jim and Jay.
So very interesting. Thank you, guys. And Jim, I'm going to go back to you and ask you, if there is a young lawyer out there that wants to do trial work, what advice would you give him or her?
Well, a couple things. One, try to get trained, either in-house or attend the trial training courses that are out there by third parties, the NEDA courses, the University of Virginia Trial Advocacy Program. Those are both excellent. Find trials. If you're in a firm that tries cases and you know a trial's going on, you may not, even if you're not on the trial, go watch it. Go to the court and see what's going on. Read transcripts. I think that's one of the best ways to learn how to conduct a proper direct examination or a proper cross-examination. Read transcripts, and then find a mentor. Find a mentor who's experienced, who knows his or her way around the courtroom, and try to learn from that person.
Reading the transcripts, that's an interesting comment. And I'll add that, I actually didn't realize how to take a deposition until I had to take a transcript and turn it into a cross-examination script at trial. So reading trial transcripts and even reading deposition transcripts, I think is an important way for young lawyers to figure out, what they're really doing in a deposition. I had no idea.
And also how not to do it.
Yeah, well, that's exactly right. A lot of lawyers don't know how to produce a usable transcript from a deposition. That's something that you can actually use in trial or in your summary judgment briefing most often. But when you get to trial, you realize the vulnerabilities of your transcript or the problems with your transcript, your deposition transcripts when you're in trial. That will help fix it.
And the terrifying part is when you read the transcript
and you read.
I'm sorry. Go ahead, Jay. I'm sorry.
I was going to say, and you realize that your memory from that deposition is not as good as you thought it was.
100%. And you read the transcript and you realize you got about 3 questions from a 6-hour deposition that you could actually use. All right. Well, let me shift gears a little bit and ask you guys an unrelated question. And Jay, I'm going to start with you this time. Hard question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Oh, wow. I guess, let's see. I don't think I'm all that interesting, but I'm right now a grandfather of 5 and dote on them as much as I can. And I have a divinity degree, Bachelor of Talmudic Law. And as anybody who ever always comments when I'm on my Zoom, my library is filled with lots of texts, which seem to occupy a lot of people's interests. So those are, a couple of facts that people may find interesting.
So what's the difference between being a grandparent and being a parent? Like, what's the one big difference?
Oh. You get to give them back, which is true. But you get to give them unlimited chocolate without anybody being able to yell at you. And so that all of my grandchildren know they get chocolate for breakfast. I call it the breakfast of champions. All apologies to Wheaties. And my children can't really say much about it.
Yeah, I was going to say, I hope your children are not listening to this episode, because you may find yourself not being in charge of the overnights any longer. Jim, how about you? Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, I guess probably something that I don't share with a lot of people is that I'm an active practitioner of transcendental meditation. Been doing it for years, and I will tell you, it is the best stress reducer when you're in the middle of trial. But you got to find those times to get your meditation in. So I always do it in the morning, and I would do it at the end of the trial, at the end of the day before we start working in the evening. And it's a really life-changing experience, I think.
Well, all right.
And a budding pianist.
Well, yeah, I'm not much of a pianist, but I've since I became an empty nester several years ago, I took up piano again. I played piano as a kid and kind of left it for a while, but I took it up again. And during the last trial, because I missed my piano lessons during the first trial, the second trial, it was like the Rolling Stones were coming into town, and I brought this huge case that had a keyboard in it, parked it in my hotel room, and took my lessons via Skype every Thursday evening.
Jim, are you near the piano right now?
I am not.
Oh. I was hoping you would treat us to a show. But unfortunately, if we can't have that, let's go to our final segment we call the Curious Hat.
And now it's time for the Curious Hat.
All right. In my right hand, I do not have a hat. When we are together, we have a hat, and I pull a question out of the hat, and then I ask the guest to answer that question. Since we are not together and I'm not wearing a hat, I have a list of questions. So, Jay, let's start with you. Can you choose a number between 1 and 17, please?
Oh, wow, that many. 14.
14. Okay. What did you wish you knew when you started your career?
What did I wish I knew? I guess I wish I understood the value of keeping up with my law school friends and college friends more. I got married in law school, and sort of when you start out at a big firm, I had a kid in law school, so I sort of my social life just was my wife and son and work. And I wish I had known that both just as a de-stressor as well as, frankly, business generation, I had kept up my relationships better.
Great advice. Jim, how about you? Can you choose a number between 1 and 17?
5.
Lucky number 5. Okay, Jim, are there any TV series that you are currently watching?
Yes, I started watching the new season of Fargo.
How's that going so far?
It's different. It takes place in late 40s. Chris Rock is in it. I don't know if any of your listeners have watched Fargo. All of the previous seasons take place in Minnesota. This one takes place outside Kansas City. It's a little different, but it's good. It's good. It's got that black humor that is the hallmark of both the movie and the series.
Yeah, and the thing I remember the movie involved a wood chipper.
That was the movie. Yeah.
But I guess that's the movie. All right, well, I think we are out of time. Thank you for joining us, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.